Welcome back to Law News, everyone. I'm Aaron Keller. I'll be with you for the afternoon hours here. We just got word recently that the Willis case out of Michigan, that's the case out of Muskegon involving a defendant named Jeffrey Willis, who's facing trial over the death of a young mother named Rebecca Bletch. That case is going to pick back up at about 10:30 tomorrow morning after being on hold. The reason is because the defense has asked the judge to consider playing some additional evidence for the jury. Hours and hours and hours of recordings of a man that the defense claims is the one that really did it, a cousin of the defendant. So that case will pick up at 10:30 tomorrow morning. It has been on hold since late last week while the judge considers that evidence. It's also been a tough case to follow because it's been an audio-only access situation for the press. We have only been able to hear audio since the judge tossed cameras from the courtroom very early on in that trial. But that'll pick up tomorrow at 10:30. We're also following a couple of other cases here on Law News. The Toledo case will be back in. You just heard some more testimony in that. First thing tomorrow morning, that's going to move into the death penalty phase in Florida. And we're also moving into another Florida trial that's eerily similar in some ways to the Toledo case. That case involves a man facing 4 separate charges related to first-degree murder. The accusation is that he killed his girlfriend, his girlfriend's parents, and the girlfriend's new boyfriend. It was an ex-girlfriend. So a love triangle and an entire family killed in that case that we expect to have coming up very soon here on Law News. In the meantime, we're going to switch gears yet again and talk about a case that's been pending before the U.S. Supreme Court. Arguments were just held, and it's the case of Carlos Ayestas. He's a Texas man who was convicted and sentenced to death in a 1995 murder case. It's up to the Supreme Court because there's an accusation his attorney just didn't do enough to help him at trial. Alan Tuerkheimer is a jury consultant based out of Chicago. You've seen him here on Law News many times. Alan, good to see you back here on Law News to discuss this case.
Thanks. It's good to be here.
So let's talk a little bit about the accusation here. A lot of procedural posturing back and forth in this case, but it really points to an issue that happened during the original trial. The accusation is that his trial attorneys just didn't do enough to dig into his mental and emotional situation, his life status, what was going on with his life, and that had the attorneys done that, it would have potentially given the jury back in 1995 something to look at to determine, hey, look, maybe this particular defendant doesn't deserve the death penalty. Now, you sit and examine juries all of the time. That's the core of your practice. Do you think that that argument holds weight? Do you think that the jury should have heard more about what's going on in this guy's life?
I think given the repercussions, which is life versus death, it's crucial that there's information that the jurors have about a person's history, because when you have the mitigating and aggravating factors come in, jurors have to decide whether or not they think because of those factors, which way do I lean? Do those factors suggest that this person should be sent to death, or should it be a life sentence? So if an investigation, or if there's a lot of effort to try to uncover something in the background and it yields nothing, well, that's one thing. But if there's no investigation, you don't know what's missing. And then it turns out in this case, in Ayestas, there are several factors that jurors could have clung to that might have changed their decision.
Well, you know, it raises a big question in the court of public opinion, and that is this one. So it doesn't seem that there was evidence that this guy didn't do it. It's just a question of what his mental state was, what else was going on in his life. And a lot of people who sit and watch trials all the time look at things like that and say, well, you know, should we really constantly be looking at the scapegoat? You know, he had a bad childhood, his teachers didn't like him, you know, something like that. I mean, is it really of the essence? I know that legally arguments can be made that it should be of the essence, but it leads to that bigger picture moral question. It's not like this is a case, in other words, where there was some DNA that wasn't tested, or there was an eyewitness who the defense didn't call to the stand, or that there was an investigator who bagged a piece of evidence that hid it from the prosecution. It's not like one of those cases where everybody would be in a big uproar about it. This is different. This is about, you know, what was going on in this guy's life. And I mean, is it really of the essence here? do jurors really bite on those arguments?
Right. That's a good point. And I think the rationale is that, yes, some of these things go on a continuum. If somebody is in a fit of rage and they stab somebody once, is that morally more culpable or less culpable than somebody who stabbed somebody 85 times? And the perspective that you just outlined, that's actually what a lot of jurors think. So you might have jurors that are in the penalty phase, and they might think, you know what, I don't really care that he had mental problems. I don't care that he hit his head several times over several years. I don't care about any of that stuff. But the point of this is that that's what should be presented to the jury, and they should have that option. Because yes, I agree with you. Some people, whether we agree with it or not, are going to just say, look, if you killed somebody, you killed somebody. I don't care what led up to it. But just to give the jurors every single bit of consideration and everything that went into it, because all it takes is one. The question then becomes, well, should they at least have had that information so they could have decided with all the information that was available? In this case, the argument is they didn't.
Well, that's certainly true. Now, what's interesting about this is that once this guy was in prison, he was diagnosed with schizophrenia. Now, to me, that detail in and of itself carries some weight. You know, it's not just a complaint about what's going on in the guy's underlying circumstances and whatnot, that it's, okay, well, maybe there is an actual mental health issue here, and maybe his defense attorney should have found out about it.
Right, and that takes it to another level because, like you say, a lot of times people might not have too much sympathy for somebody who, they did a couple bad things, or maybe they were physically abused. Different people have different interpretations, but once it gets into the realm of mental health, most jurors know somebody with a mental health issue, or they know enough about it where they would evaluate it differently. I think they would have look at the information through a different lens when they start hearing about schizophrenia and mental health, because then people start to think, well, were they really in the right mind? Why did he actually commit this crime? And so that's pretty key information. And I think with that it's a whole new ballgame, just because otherwise it becomes a series of arguments that are made all the time that someone might embrace about what happens during the regular course of things. But I just think that it's another level. And when jurors hear that there's mental health, especially if it's a delusional or some type of psychotic disorder, schizophrenia, then it's a different consideration.
Well, let's ask another question. How would a jury in Illinois, where you sit, versus a jury in New York, versus a jury in Kansas, versus this jury where it was in Texas? And we know Texas is a state where there are a lot of death penalty convictions and a lot of executions carried out. You know, some of this is a societal function as well. Now, let's assume that all the states that I named had the death penalty. Would a jury in Texas still look at this schizophrenia situation and say, you know what, we don't care, it should still be the death penalty?
Yeah, and that's everything does derive from the culture, because that's jurors come with their attitudes, their experiences, and they're a product of where they live. And certainly the sentiment for the death penalty is different in a lot of these venues you mentioned. I think jurors in Cook County, more urban areas where the death penalty is not something that is as prevalent, or at least it's not something that people are in favor of, whether or not it's part of the punishment or not, people still think about it. People think about the death penalty in states that don't have it. But yes, I think that somewhere in Texas, where a lot of this is ingrained, as people just on a regular basis, they would probably be more inclined to disregard some of the evidence, even if it's to an extreme degree about schizophrenia, or if it goes to the heart of whether this guy knew right from wrong, whatever the consideration was. It certainly does vary by region, and you can see that sometimes in the jurisdictions, because in most of the jurisdictions, what I understand, and the federal ones too, an investigator is provided by the court, whereas this in Texas here, where I think it's Louisiana, and Mississippi, and Texas, the reasoning in that case that was in the lower court was that you could only have this investigator if you knew what the results were going to be, which doesn't make sense, because you need the investigator to know what it's going to be like. So there's certainly geographical differences in how people look at the death penalty, and that does get played out a lot.
And let's talk a little bit more about procedurally where this case sits, because, well, first of all, it made it all the way up to the Supreme Court, so they're biting onto a specific issue here. And it's tied up into a lot of statutes and this, that, and the other thing. But we've got this issue of the mental health situation, and it's rolled up in this claim that counsel didn't do a good enough job digging into it. And then that itself is rolled up in another claim that deals with how the courts dole out money for defense investigations for a defendant to prove his or her own case, where a defendant is indigent, can't afford to do it on his or her own. So you've got a lot of moving gears in this procedurally, which to me makes it interesting, but it boils down to this age-old question that if a defendant has more money, is the defendant able to put on a better trial? And it doesn't necessarily have to do with the hiring of the counsel. It has to do with the degree of testing that is done, the amount of evidence that is discovered in the first place. Now, that's a legal issue, and it has to do with a question of how much government money do we want to go at these situations, okay? And it also has to do with where are we channeling the government money that we have, because when it's a murder investigation, the state, theoretically, as a defense attorney would argue, has unlimited resources. Well, what about the defendant's resources? And we kind of play this this game where we say, well, you know, the police are supposed to turn over everything that could both implicate and let the defendant off the hook, evidence that is both favorable to the state and favorable to the defendant. But when it comes to mental health examinations, I mean, the police aren't digging into mental health situations. They're looking at DNA, fingerprints, medical examiner's reports, things like that. You know, does this boil down to the age-old question of money and how much money we want to throw at a situation?
I think that's a lot of it. I think a lot depends on the resources and who has the financial wherewithal. Look, for people who have more resources, they could hire counsel that has more experience with this. They might not get appointed an attorney. They might hire someone like me, a jury consultant, to do a focus group and figure out what are the factors that are going to be favorable and what are going to be unfavorable. If there's a venue where somebody is condemned to death or the death penalty is on the table, they might think, okay, well, this guy has a drug history, and so he used to abuse drugs. Well, do we know if people think that that's going to make him more sympathetic, or if people are going to say, well, he's done drugs, so no, that's actually makes me more likely to think he's not going to be a good citizen, or say that he was abused physically or emotionally or even sexually. Some people might be sympathetic, while others might think, you know, he just had, I know this has been rough, but he's probably, since he's been a victim, he's going to be a perpetrator. So that's the type of thing where you might want to get in the community, get some attitudes, or at least get some more information where it just costs money to get at those types of things, where your average person who's sitting on death row isn't going to be able to do that. And so, yeah, if there's so many opportunities in the process where having more money, being a better financial situation will help out. And this is certainly one of them. You just have more options to dig a little deeper, learn about the venue, and decide what can you present that's going to persuade people to, or ultimately maybe just one person, but keep people from signing the death penalty.
Well, this boils down to a really difficult argument, because let's say, for the sake of argument, let's say I'm somebody who's very conservative and I don't like this idea of oodles of money flowing out the door of the public coffers in order to have a police investigation and then have 20 million pounds of investigatory might on behalf of the defendant, and we're paying for this, that, and the other thing. And ultimately, that's what the Solicitor General is arguing. The government's case before the Supreme Court was partially that because the doling out of money is an administrative function, not a judicial function, that the Supreme Court can't even hear the case. Now, the liberal justices on the court shot that idea down during oral arguments yesterday, but that's one of the arguments out there, and here's the problem is that it sounds fiscally conservative, but when you take a bigger look under the covers as to what's going on there, it ultimately results in the conclusion that, you know, it creates a more powerful government that doesn't give people a lot of resources before locking them up and putting them to death. So it's a hard issue to get around, at least from the stereotypical political persuasions, which I know ultimately aren't going to win the day in a court of law, but it does create a conundrum. A big question as to, okay, well, should the government have the power to ultimately withhold resources from a defendant? And if the defendant had access to those resources, could potentially have kept himself off death row. That's a tough argument to boil down to low gravy, but I would think that if we're going to live in a country where we say there's a presumption of innocence, that people who are accused ought to have every shot they can get to try to prove their innocence. Otherwise, the rest of us look at the case and say, can we really be comfortable in the verdict as it stood?
Right. And there's so many different competing perspectives and there's so many layers to this, but I think you're right. I think that even if somebody is the most fiscally conservative, lock them up and throw away the key, I think that ultimately, if that's the type of person that doesn't believe in the presumption of innocence, that is just going to go there and just vote guilty, death, then that's the kind of person that you have to be really concerned about in the jury selection process, because that type of person should never sit on a jury. So that's why it's really crucial in these cases, in all cases, but especially a death penalty case, because some people have that mindset. Some people are going to show up and they believe that when there's a prosecution of somebody where there's smoke, there's fire. And if they're in favor of the death penalty, which again, if you serve on a death penalty case, you're already pre-qualified. It's a death qualified jury. So you're going to have a certain subset of the population that believes in the death penalty anyway. But it is really important, and prosecutors will tell you this, they might not want this person not on the jury, but anybody to serve on the jury, no matter how strong their convictions are, how conservative they are, they need to ultimately understand that there is this presumption of innocence, that defendants don't have to prove their innocence, that there's no burden shifting. They have to understand the standard, and then in most cases where it runs smoothly, there's information that comes out in the death penalty phase after there's a conviction, whether or not that these aggravating factors or mitigating factors. And one would hope, no matter what side of the political persuasion you're on, or where you fall on a whole host of socioeconomic scales, you believe in that and you understand that, yes, this person is entitled to fair representation and a fair system of justice.
It's not unlike some of the arguments that we're seeing come out in the Making a Murderer case, of which I'm very intimately familiar, having been up there for it. And I know I'm sort of throwing you a bit of a curveball, Alan, but it's ultimately a similar argument to what Stephen Avery's post-conviction attorney is saying, that he didn't have the resources to dig into the case as well as she thinks it should have been dug into, and is now spending hundreds of thousands of dollars trying to retest evidence, dig into whether or not blood samples were planted or weren't planted, trying to dig into this, that, and the other thing. So, ultimately, we've got a lot of cases in the public consciousness right now that raise this question as to, well, should defendants have rather unfettered access to the government coffers in order to prove their innocence? And we've got a system that presumes innocence here, whereas the state can throw hundreds and thousands, millions of dollars at an investigation if necessary to try to prove guilt.
Right. It's such a tough question. And it's what you said in the Avery case. If he was able to do that in the beginning, it would have cost a whole lot less money, because now they're spending so much money on all this testing and doing everything else after the conviction. So it's a good question. And I think people have to think about, okay, what are the priorities with every big decision? You have to think, okay, we want a smooth system of justice. We want it to be effective. We also, some people would say, we have to think about victims in these types of cases. So we don't want these appeals to go on and on and on. And as a result, what is your priority? Now, hopefully most people have want to put emphasis on the presumption of innocence. But again, this is kind of how we started. We've come full circle, that people who lack resources, they, in many ways, start out at a disadvantage. And then as they go through the process, there are all these hurdles that they have to face, hurdles that can be overcome if somebody has the money and or financial wherewithal to overcome.
Yeah, it raises a big question, and I think that it's one that would bother anyone who's concerned about this presumption of innocence. And in your work with juries, I know that you primarily work in the civil realm, but when you dig into what a jury may or may not be thinking, or when you run a focus group, what's your sense of how juries try to understand the burden of proof? You know, we hear beyond a reasonable doubt in criminal cases, and I think it's part of the American lexicon where most people in their daily lives can rattle off somebody has to be proven guilty beyond a reasonable doubt. But do juries struggle with that from your perspective? Do civil juries struggle to understand burden of proof? And, you know, I'll just ask the question that way simply.
Yeah, no, I think what juries struggle with is that it's really up to them. I mean, yes, there's this burden, but what does that actually mean? It's up to them to determine whether or not something's more probably true than not. It's up to them to decide if something's been proven beyond a reasonable doubt. So once they're empowered to do that and realize that there's nobody else who's going to determine whether or not the state met its burden or a plaintiff met its burden, it's up to them. And I think they do a good job of trying to understand that. And when you have 6 people or 10 people or 12 people, most of them try to diligently understand that and respect the burden. Now, there's always a small handful. I'd say you can have maybe 1 or 2 or maybe up to 3 people in a jury of 12 that, whether or not they even try to do it, subconsciously sometimes they expect a criminal defendant to prove innocence or a civil defendant to show that they're not responsible for injuries that the plaintiff are claiming. Now, they don't often get up there and say, I believe that the defendant should show that they're innocent, but it creeps in sometimes because it's such a new concept to them, and people in the legal field, legal media, and people who have studied it, it's second nature to us. But for people where it's something new, or maybe they've seen it on a TV show, there's something about a criminal defendant, whether or not they take the stand or not, they want to know certain things. They have questions, they want to know the story, and if it's incumbent upon the defense to show something or convince a jury of something, and it often is, then they might in a way just elevate that standard or lower the standard a little bit because in their minds there's something lacking from the defendant's case.
Well, you know, I saw a poll that was taken a couple of decades ago, so it was before the explosion of coverage of trials such as what we do here at LawNewz. But something like 50% of respondents thought that a defendant had to prove his innocence. And, you know, that's not the case at all. So in this case, though, the Ayestas case that the Supreme Court heard arguments about yesterday, really interesting in that, look, the accusation ultimately is rolled up in this ineffective assistance of counsel. But there's other questions as to whether or not the court should have approved more money, okay? And questions about whether the information that could have, in theory, been found by the counsel would have really made a difference. I'll throw this out there sort of as a last point to chew on, Alan. Really, I guess the only case that the defense put up as far as the defendant's mental health or really anything to mitigate this, because again, the death penalty phase has to do with mitigating and aggravating circumstances. If it's an aggravating circumstance, it's a check in the column of giving the death penalty, and if it mitigates, it's a check in the column that maybe it should be a life in prison sentence. But apparently, the way the defense tried to deal with it in this case was basically to submit documents that the defendant had been a good student. And then it turns out later that he has schizophrenia. Now, I'm asking you to put your Supreme Court hat on, Alan, but if you were a justice sitting on that court, would you turn around and say, hey, look, proof that the guy's a good student is what you've got at trial, and it turns out the guy really has schizophrenia? Does that, in Alan Tuerkheimer's world, make a case for ineffective assistance of counsel?
I think it does, just because that's what they uncovered, that he's a good student. I think he took a language course in prison, because if you hear that as a juror, and thinking as a justice, you have to think about how the jury would interpret that. That means that that's all there is. I think that juries usually assume, and justices realize that juries usually assume that what you hear, it's the best case that somebody's putting forward. So if you're a juror in the case and you hear that, you think, okay, so that's all there is. I'm going to vote this way because of that. I'm going to vote in favor of the death penalty because there's nothing else.
You know, yeah, I mean, that's just a bizarre thing here. Like that's all they've got to try to mitigate. But
right.
Look, I'll say in defense of the trial counsel, the state of Texas presented an affidavit when this thing was going up through the chain on appeal that ultimately said that the client had ordered or asserted that his trial counsel not communicate with his family, and the family seemed to want nothing to do with him. You know, might this have been a situation where, and I think that there's no way we'd ever know because of attorney-client privilege, but that kind of reeks of a situation where there's a very difficult client.
Right, and that's a whole nother X factor. A lot of times when we argue about these things and talk about them, there are certain things we accept as a given, but then you throw that in there, and then it makes you wonder, well, how cooperative was this defendant, and what are the other variables that led to the attorneys basically saying he was a good student and nothing else?
Yeah, it raises so many questions, and the issues are all sort of wrapped up in other issues. So it'll be really interesting to see where the court comes down on this, especially if the court reaches that issue of the money. Because ultimately, when an attorney applies for money from a court to try to do something, one would assume that traditional notions of fair play and justice should result that, you know, look, if I don't have the money to pay for an attorney, but I think there's something out there that could help my case, well, if the state has all this money to work with, why not the defendant? I realize that it's not a fiscally conservative argument, but this really makes me wonder if part of the reason the Supreme Court bid on this case and decided to take it is because of this underlying issue of how the various circuits and district courts, and to a degree the state courts, are using their money, and whether we're going to be so bold as to say that there are constitutional provisions that will require the expenditure of money in cases like this to ensure that the defendant has access to some independent investigation tools.
Yeah, I think you're right. I think the Supreme Court wants to at least provide some type of uniformity, realizing there are different jurisdictions and there are different rules, but at least this is such a fundamental question that's part of the reason why they decided to hear the case.
Yeah, I'm going to be really interested to see the way that turns out. I think that from what we heard of the oral arguments, I hate to say this because a lot of people try to politicize the court, but from my understanding of the oral arguments yesterday, the so-called liberal justices were really on this idea, and the so-called conservative justices tended to not be very into this idea. So it could be months and months before we have a resolution, but now I'm interested. I want to see how this turns out.
Yeah, it could come down to Justice Kennedy and what his swing vote is if it goes along those lines, which it often does.
Oftentimes it's 4-4-1, and that one person is the moderate, Justice Kennedy, who is the moderating factor on the court. Not to say other justices don't sometimes change their mind. Justice Scalia, oftentimes referred to as a deeply conservative justice, he's no longer with us, but even he would change his jurisprudential approach when it resulted in a conclusion that he wasn't willing to live with morally. I can't remember the case right off the top of my head, but I know that it's out there because we talked about it ad nauseum in my constitutional law class. So it'll be interesting to see how this tallies out. Alan Tuerkheimer, jury consultant in Chicago, great to have you back on Law News.
Good to be back. Good seeing you. Thanks.
Okay, we'll catch you next time.